Hello, my name is Joe Facenda. I am a realtor with REMAX Gateway here in Northern Virginia, just outside of Washington, D.C. And I've been a realtor here for over 30 years. In the last several years, I've made working with inherited property a specialty of mine. And in fact, I've written a book on inherited property called When Parents Are Gone, What's Next with the House? And it is available on Amazon. In this section of videos, we're answering the question, who's responsible for the property, who needs to sign any paperwork related to the property, and when can you act upon your plans? The answer to those questions depends upon how you received the property. In this video, we'll answer those questions, determining who signs, and who's responsible for the property and when you can act if the property was received via a will. And the answers to those questions are not as clear-cut when a will is involved as they are with a trust or with a transfer on death deed. The first step is to go to the county courthouse and present the will to the court. The court will determine if the will is a valid will. If the will is not a valid will, then whatever's in there doesn't apply, and the property will transfer to heirs via the laws of your state and your jurisdiction regarding transfers without a will and without a trust. And we talk about that in another video. If the will is valid, in the will, there will be an executor named, and that individual, or it could be individuals, are responsible for administering the will, following the wishes of the deceased, and running other aspects of the estate. The executor named in the will may or may not have authority to sell the property. This will also be determined by the court. If the executor has the authority to sell the property, the court will add a letter to the file, so to speak, stating that the will was reviewed and the executor has authority to sell the property. In that situation, that individual can sign all paperwork, decide what to do with the property within some limits, which I'll touch on. And if they were to engage me or a realtor to sell the property, the executor would technically be the client. Now, if the executor does not have authority to sell the property, then the beneficiaries named in the will be the people who will sign all paperwork and act upon the property. So timing-wise, you really need to find out if the will applies. Does the executor have authority to sell? Is it the beneficiaries who will be signing all paperwork? In some cases, the executor and the beneficiary are the same person. Say the last parent has passed, there was only one child. That one child was named in the will as the executor, and the property is going to that one child. In that situation, you could sell the property, that only child could sell the property as an heir at any time before probate. We'll talk about other issues involved with selling as heirs in the other video, but the process can start earlier if the executor is the only heir or the only beneficiary of the will. Or let's say that last parent passes and there are 4 siblings and the oldest child is the executor and the other 3 siblings all agree to sell the property. Same concept applies. If they are the only beneficiaries in the will and they also are the only heirs, they can start the process earlier prior to going to court. But you need to be sure that you know who the heirs are, and that can be complicated, again, discussed in another video. Simple situations, only child, 2 siblings, no siblings have passed. They are the beneficiaries in the will. You can start whenever you want. Many wills that I've seen involve donations to charity. So, and it says that the house will be sold and the proceeds will go to charity A or B. I had one recently just like that, where there was one sibling remaining in this family, and the deceased did not give anything to that sibling and gave half the proceeds to one charity and half the proceeds from the sale of the house to a different charity. So in that case, you need to get, if the executor has the authority to sell, the executor can sell the house and make sure, the proceeds are split. If the executor does not have authority, then you need to get the charities involved and who's going to sign on behalf of the charities, and it becomes a little more complicated. So again, in summary, go to the courthouse, determine if the will is valid, determine if the executor has the authority to sell the property, and proceed from there. I hope this has been helpful, and certainly willing to answer any questions about your unique situation. Just reach out to me at any time. You may want to next go to another video in this section outlining what happens if you receive the property via a trust, if there's neither trust nor a will, or you receive it via transfer and death deed. But I'd suggest that maybe the next important video for you is the video stating, when discussing what should be done early in the process to prevent future legal issues, and also to get ahead of any potential tax issues. Wherever you go, I'll see you there, and we'll continue the conversation then. Thank you for watching this video.